Before we start the program, I would like to give you some housekeeping information. We encourage attendees to use the computer audio for this webinar. Should you experience any audio issues, you can use the optional phone connection, which is located on your screen below the webinar slide player. We will have a live Q&A program or session during the program. You may submit questions at any time using the Q&A function. After the webinar, please visit the program attendee page to ask additional questions and to access a copy of today's webinar. Welcome to Pro Bono Best Practices, Part 4, Navigating Difficult Conversations with Pro Bono Attorneys, sponsored by the ABA Commission on Immigration. To receive CLE credit, you must attend the entire program. Partial credit is not available. Please click on all the participation verification alerts to confirm your attendance. After the program ends, a link to complete the certification process will appear. Please complete the evaluation and the CLE affidavit, providing your bar information as requested, and submit it. Once your attendance is verified, your certificates will be emailed to you. Moderating the program today is Marissa Levette. Marissa is an Assistant Staff Counsel with the Center for Pro Bono at the American Bar Association, and she is located in Chicago, Illinois. Marissa, please proceed with today's program.
Thank you. Joining me on the program today are Emily Brock, Narina Subatian, and Becky Wolozin. Sorry, Becky. So Emily is a children's program senior staff attorney at Rocky Mountain Immigrant Advocacy Network. Narina is the immigration pro bono managing attorney at Winston & Strawn, and Becky is the immigrant justice program senior attorney at Legal Aid Justice Center and the director of the George Mason University ASLS Immigration Litigation Clinic. So this is the fourth in our series of our Pro Bono Best Practices webinars. So I hope that some of you were able to join us on previous webinars, but if not, I think you're in for a great conversation today. So we're going to talk about some of those difficult conversations that come up with pro bono attorneys and some of those challenges that might come up and how you can address them at the outset and then also address them throughout the representation. So we're going to start off today with some of those conversations you should have at the very beginning of the representation and also whenever you are starting to determine whether or not you're going to take the case and where the best placement for the case is. So let's start out. What are some of those conversations that we can have at the very beginning to address maybe some of the challenges that can come up at the outset? And I'll go ahead and start with Narina.
Thank you so much, Marissa, and thank you to the ABA and my co-panelists here. I'm very excited to speak about this topic. I was saying we can probably talk for hours. So just, I think where to start, right? And from my perspective, so I'm at Winston & Strawn, and I've been in my at my firm for about 7 years now. Prior to that, I come from a legal aid background. So I think the benefits of having had the experiences at legal aid and then also now being in the firm position is to see the different resources and the different types of conversations that maybe happen around pro bono. So I think a really good starting place for me is to think about, okay, what are we trying to accomplish with this relationship? Because it's relationship building. One, of course, we are trying to serve a client, but then two, we want to continue to build a relationship with the agency. We want to continue to invest in more pro bono work. So how do we do that from both perspectives, or actually three perspectives? The client perspective, thinking about what's good for the client, a good experience for the client, what's good for the agency, how are we going to be helping the agency by alleviating maybe their caseload or giving them our attorney resources, but then also what's good for our attorneys. Are they going to have an enjoyable pro bono experience too? And so I think just thinking about those few things, the why are we doing the work, the who are we assisting, and the different players or the components really helps inform the type of cases that maybe are fit for a pro bono service, meaning should we be looking at maybe cases where we have done a very thorough intake and vetted some of the issues as like, is there consular processing issues, going into maybe some of the more details of what to think about the case and strategy and who's going to be working on what, but also to have the conversation beyond the specifics of the case, but who will be providing the mentorship. What are the expectations? Is the firm expected to mentor the attorney who's going to work on the case? Will there be external agency resources from the nonprofit agencies? What about if additional issues are identified beyond what was done in the intake? So who do we contact? How do we continue to make sure that this is a really good experience for the client, for the firm, and for the referring agencies, so that we can all keep doing more of this work? And I think Emily had some more specifics maybe that she wanted to add, but for my part, those are sort of the things that I think about as far as the relationship building and the conversations to have at the beginning.
Yeah, no, I think those are all really good kind of foundational issues that need to be addressed and talked about when setting up that relationship between the agency and the pro bono, whether it's a firm or a small, a single practitioner, right? And from my background, I've basically worked in nonprofit my entire career, so the perspective I have is kind of helping kind of pro bonos that don't necessarily traditionally work with our population to sort of engage in that initial conversation with a client that they aren't necessarily used to dealing with. There might be language issues, right? A lot of our pro bonos don't speak the language of the potential client, and so I start with kind of coaching the pro bonos to make sure that they understand what the best mode of communication is, right? We refer a lot of kids cases, especially teenagers cases, and those kids do not answer their phones, right? They don't want to talk on the phone, they want to text. So like, have you had that conversation with the client? What have you confirmed that the volunteer interpreter that we've set you up with is being understood by that potential client? Because there have been situations where it's a communication issue, and that can lead to beliefs of credibility issues, or just a miscommunication between the pro bono and the client. And then also just making sure that everybody's on the same page as to who can have information about their case, who can participate in the preparation of the case, and who is someone who absolutely should not even know that the case is happening, right? We want to avoid any of those conflict issues up front, to the extent that we can, right? But helping pro bonos kind of outline those issues from the beginning and having that initial conversation is what we have found to be pretty successful, and just allowing that pro bono to understand that your first conversation with the client might just be those questions. You may not even get into any of the sort of legal issues or factual findings.
Becky, did you have anything you wanted to add that we got from your perspective of any important conversations at the beginning?
I think the only thing I would add is to make sure really these initial conversations are about expectation setting with the client, with the pro bono coordinator, and with the pro bono attorney. And so those expectations have to be set individually with each of those people. So the client needs to understand, what does it mean to work with the pro bono attorney? What does that attorney provide, and what do they not provide, right? And what are they going to expect, or how should that client, especially if they're a kid, where this is sort of an initial interaction with a lawyer, how should that client figure out what they're supposed to do? What are the ways to engage in this relationship? I think for a lot of our clients receiving pro bono representation, this is a learning process for them too. And so it's important to keep that in mind at the initial screening, and then as you're deciding which client to send to pro bono attorneys, and as the pro bono coordinator sort of being the mediator between them, making sure that everybody's roles and responsibilities is really clear can, I think, save a world of pain farther down the road.
Those are really great points. So moving on from maybe some of those conversations that you have at the very beginning, When we're talking about case strength and some of the challenges that can come up after those initial conversations, what do you do whenever there is some inconsistency between that initial intake and some of those first conversations with the pro bono attorney? Becky, I'm going to start with you on this question.
Yeah, so I think expectation setting is key, right? An intake interview is never going to reveal the full scope of a case. It is an initial meeting with somebody the client doesn't know, may not trust, and it's probably pretty short. So while an attorney might spend, as you all know, might spend hours with a client, an intake screening process is maybe an hour, pretty quick to get just the basic information. So I think it's important, this audience being mainly pro bono coordinators, right, to set the expectation with the pro bono attorneys that there will almost always be some kind of inconsistency, something that didn't come up in the original intake, or some incompleteness, and that is not a sign that the client is bad. That is not a sign that the case is bad. That is to be expected and worked into the case plan. So I have an example in case this is helpful, and I think it can be helpful. Again, I think that this is really a lot of pro bono coordinator work, sort of setting expectations and guiding people through the bumps of working with real people and not hypos and not, case descriptions. But I had a client who was referred to me from another nonprofit organization as a particular kind of asylum case based on abuse by a husband. And there was all this description of her case in her credible fear interview, which I got. The first time I met with her, she was very nervous and she said, I think I said this in my credible fear interview. I was like, okay, well, let's push through that and just answer. Don't worry what you said in the credible fear interview, just answer what actually happened to you. Over the course of 2 to 3 meetings, right, so not the first meeting, it turned out that her credible fear interview was wildly inaccurate. It was not the case that I thought had been given to me. She had not been accurate in the telling of it. So I don't think it was even necessarily that the other organization who gave it to me thought that was her case based on their fairly brief interaction with her. That was concerning, obviously, and raised a lot of issues for us, but it didn't tank the case, because if you can adjust and be flexible with your client, then you find the way to work with what you've got. And it's kind of, I think you can't fight the facts. You can only have the facts you have and work with them. And I'm really happy to say that we won that woman asylum, but it took a lot of work to get her through the trust barrier to be able to tell us exactly what had actually happened to her, both in her home country and at the credible fear interview, where she was having a lot of mental health issues in the interview. And we were able to suss that out. But I think making it clear to the pro bono attorney taking a case that this is not a corporate client. This is not a client where you're going to give them a list of things and they're going to produce them, right? This is a client that's going to need some human coaching, and really trust building and relationship building in order to get the information you need. And that will be part of the representation. And that's not a non-legal skill. I think this is sort of key, and I think pro bono coordinators should probably spend time on this. I can say this because I teach law students all the time, and they don't learn this except in my clinic, is the skills about how to talk to another human being. That's not a skill that's really taught in law school, but it is a really essential skill for immigration attorneys, right? So as the pro bono coordinator, thanks to our fantastic legal education, that's going to fall on you to really guide a lot of the pro bono attorneys through that aspect of the case. They can handle looking up the law, but they're probably going to need a lot of hand-holding or a lot of guidance for dealing with messy clients, messy facts, and just interacting with people. So I'll say my mantra that I like to share with people, which is that when working with clients, you should always start from a place of radical love and acceptance. You're not going to change them. You're not going to change their facts. You're here to be open and accept them where they are, meet them where they are, and work on their case. And then hopefully that can help set expectations and baseline understandings for really productive work together through the rest of their case.
How would you as a pro bono manager instruct some of your attorneys on identifying and evaluating some of these potential credibility issues with the case? And I'll go ahead and go to Emily on this one to start.
So I think, again, I'm going to go back to something Becky said, which is like preparing the expectations, but also like our model at Remain is we have pro bonos do kind of a CLE education program before they take, especially if they're going to take an asylum case or something that's primarily immigration based, because we kind of go through training sessions on the fact that credible fear interviews are often inconsistent, right? Because of interpretation issues, because of trauma issues, because of just people focusing on one part of their life and not realizing that another thing that happened to them that they don't necessarily think is the worst thing that happened to them is actually the stronger part of their case, right? So we try to set people up for basically to understand that there are going to be inconsistencies, right? And that there is going to be something in the record that is going to make you go, oh, I don't know how I'm going to deal with that, but I'm going to have to deal with it, and kind of give them other sessions on, how to build, kind of how to rehabilitate something that's in the record, right? We talk about how to work with mental health professionals, right? There's a whole session on how to work with mental health professionals in your case. There's a whole session on cultural competency, right? How you understand the context of people's statements and how they tell their stories, right? It's not necessarily the way, Mr. Immigration Officer or immigration judge wants to hear it, right? So you have to figure out how to, while staying true to that story, kind of tell it in a different way, right? But without undermining the cultural competency. So I think our main strategy is to give that education up front and then make sure that everybody has competent and very experienced mentors. We have a whole panel of mentors who are immigration practitioners who deal with this regularly and who can get on the phone and say, whoa, take a deep breath. Like it's okay that the credible fear interview did not mention, the fact that she is a survivor of domestic violence. She was focusing on the gang, renta, she was focusing on the gang threats, but that doesn't mean that her case isn't also accurate. So I think that's kind of how we manage it a little bit.
And what are some ways that you work with your attorneys to sort of rehabilitate or maybe distinguish some of these issues that might come up? Are they, I think Emily, you brought up a great point about, is it related to trauma or is it related to language issues? But how can you train some of your pro bono attorneys to remedy some of these situations and maybe distinguish them when they're actually handling the case? And this is kind of an open question to the three of you.
I can give an example. We had a case where the pro bono had a merits hearing that was split, actually, which drives me nuts, but they had ran out of time, and so they had to go back. And one of the things that the government attorney had raised was that the client had said that she'd been pushed to the floor, but in her declaration, but in her testimony, it said that she'd been pushed onto the floor. and that meant that it was an inconsistency, right? Which of course is not an inconsistency, right? It's the ground. She said floor or ground, and it was a matter of what the interpretation is. So, we were able to coach the pro bono to go back and ask the client again on the record to describe the ground, the floor, even though it was completely irrelevant to the fact that she had, whether she was pushed to a dirt floor or a floor in her home was irrelevant to the fact that she was being abused, right? But it was then to coach her, this pro bono, to make sure that the interpreter somehow conveyed that there were two different words that could be used for the same meaning. So that's one way. And then also one common thing that we use is mental health evaluations that outline what trauma does to people's ability to remember things in a linear fashion, for example, or how it impacts people's ability to remember specific details in all instances of trauma, right? So they might really remember one instance in detail, even though it was a lot longer than one more recent incident, because of trauma, because of the impact of multiple traumatic experiences.
I'll just add from the firm end or my practice, when we do have, say, an asylum case that's placed, our attorneys receive robust training in addition to what they're receiving from the agencies that we take cases from internally. So they receive specific resources about working with, having a trauma-informed lens, working with clients who've gone through trauma, how to, as Emily mentioned, work with mental health providers, but also there's some additional sort of like FAQs that I've put together of things that come up routinely in this practice, where I think when we started the conversation, it was like, you may not be working, our firm does not have a commercial immigration practice. So all of our attorneys who work on immigration cases are doing it on a pro bono basis. And so there's the learning the language of immigration plus learning the language of working with clients who have so many other issues maybe that they're working on in their lives and experiencing. And unfortunately, I always tell our attorneys, I think the most difficult part of being an immigration practitioner is we are not mental health experts, and we have to ask people a lot of difficult questions, and that's what I tell the clients too. So in the introduction to the cases with the attorneys, it's having a conversation about all these difficult things, mental health, but really stressing, I think, the relevance of mental health and asking people questions about difficult harm, persecution, things they've suffered, and the relevance of all of that. So building rapport with the clients, having the conversation be, I understand that this is very difficult, but this is why we're doing it, right? The explanation, and it's not just an exercise of trying to re-traumatize the client or to have our attorneys take on this case and ask people very difficult questions, but also being ready with resources. And I think we're going to talk about that as well. But as far as with, inconsistencies, we have it maybe come up in the context of, because we'll oftentimes work on affirmative asylum cases. And then if the case is referred to immigration court, we will oftentimes continue to represent the client. So really, I think Emily and Becky both mentioned this, and Marissa as well. It's not necessarily an inconsistency. It may be the incompleteness of the information. So how you're framing the information that you're sharing with the government, but also on my end, training the attorneys, the pro bono attorneys, to understand that what we may not perceive to be an inconsistency is what maybe the government will interpret to be an inconsistency. So how do you explain that in a declaration on or about approximately explaining why you don't remember something, client, right? So anticipating what may be perceived as a case issue that's not really an issue, but has a reasonable explanation, and providing that explanation up front so that it does not then, transition to like a larger issue than it needs to be.
Yeah, and I think what I like to do is give people frameworks that they can use regardless of the case, right? So knowing that there will be inconsistencies, you have to actually be probing for credibility issues at every point along the way. And making sure your client understands the reason you're testing this is because you want to be able to prepare them and help them as much as possible. And you don't want things to come up when you're on the hot seat, when you're in the hearing. So I think I would give a framework of first identify and evaluate credibility issues, then distinguish whether it's actually a contradiction or if it's incompleteness or an interpretation mistake. So you want to distinguish what type of credibility issue it is, then evaluate whether it can be remedied. And that could be, if it's not a complete contradiction, what are you going to do? If it is a complete contradiction, what are you going to do? Can you fix it or can you not fix it? And then evaluating how you might remedy that. Are you going to need outside experts? And that could be psychology or psychological evaluations, but it could also be sociology experts. It could be country conditions experts. It could be other witnesses who can clarify what was going on. You have a whole wealth of tools to contextualize and explain. And so this evaluate section is really important. And then actually remedying it is sort of the end of all the credibility work. And that might happen in the hearing for something you've prepared, or it might happen for something that comes up that the government thinks is a contradiction that you don't think is a contradiction. But having already understood how to identify, distinguish, evaluate, and remedy other credibility issues, you can then apply the same framework very quickly in a trial setting. So as pro bono coordinators, hopefully you can give that kind of framework to your attorneys that you're working with so that they don't sort of get completely derailed by something that someone else perceives as a credibility issue or something that didn't come up before with the client.
And I think that some of the things that all of you have said really are a great segue into kind of our next topic, which is attorneys venturing outside the scope or kind of not venturing into some of the other realms of services that a lot of the clients in particular in immigration and asylum cases need. So how can you help your volunteer attorneys when they're whenever there are things that come up in the case that maybe are outside the scope of their representation? Emily, I'm sorry, Becky, I'll go ahead and start with you on this one.
Sure. So I think it's hard because an attorney that's doing all this work to make the trust and relationship building connection with a client may feel either obligated or just really want to help the client they're working with. And that's especially true if it's a person who's newer to this type of case, right? Once you've done it a few times, you sort of figure out what your own boundaries are. But for people that are new to helping out this type of client, I think there's a real tendency to sort of go too far. And important ways of sort of helping prevent that and also preserving your attorney's capacity to take more cases, which I think Narina can talk a little bit more about, but is to make sure they know what types of things might come up and that they have access to whatever resources you as an organization have put together for those non-case specific needs, social services, public benefits, frankly, like childcare. If childcare is going to be an issue for all of your client meetings, like they might have to either spend some time thinking about childcare with their client or reach out and find some other resources that they could provide their client if it's important that kids not be in these meetings. So there's like a little bit of legwork that the pro bono coordinators can do up front to sort of have a toolbox ready and to warn attorneys that like this is likely to come up and it's not your responsibility. And frankly, we'd rather you put your energy into the legal case and let, the client figure out this other stuff or us help with this other stuff so that you can really focus on the case. And presenting it in that way, I think, is hopefully helpful to pro bono attorneys who might otherwise feel really inclined. I had a friend once who was representing a client. She's at a firm. And she called me. I mean, she's in New York. I knew nothing about the client, but I do immigration. She panicked and she called me and she was like, what do I do? My client just had twins. They're early. Like, she doesn't even have a stroller, all this stuff that had nothing to do with her legal case. And she was like, she's calling me and like, what am I going to do? How can I get her what she needs? And we sort of had to walk through like, okay, like, what are the resources near her neighborhood? Which organization gave you this case? Like, who can you reach out to in order to get some support on this sort of non-case specific stuff that is very important to the client's life, but not central to the client's legal case in this moment. So I'll pass it on to others who have good advice on that.
Yeah, Becky, I think all of that was great. That's really what I tell a lot of the folks that I'm working with as well, that there are a lot of resources out there. And I think part of it is because, all of us probably are working in this space daily. So we are aware of the resources. There are so many state resources or city resources. Resources are constantly changing, right? So I think being in great communication with the referring agency and knowing some referring agencies have social services in-house. Some are contracted to get other services by certain cities and counties, states. So all of those resources frequently change. So even if I know of a resource, I like to always go back to the agency and say, hey, like this is the need right now. There are certain things that we can help with. But really trying to stay within the realm of the legal work, because as you said, when we take on more work beyond the legal work where we are the experts, then maybe we don't have as much time to take on another legal case. Where I do like to have the attorneys, what frequently comes up for me, I would say, beyond social services or non-legal questions, are also expanding the scope of representation, right? So someone will come to us and the case will be placed maybe as a SIDGE case, but and hasn't, the intake has not revealed that there's anything else, but with additional vetting, conversations, rapport building, it's like, oh, we're identifying some of these other issues. Perhaps there's another immigration legal remedy. So do we then expand the scope? So those are conversations that I frequently have with our pro bonos too, which ventures outside of the initial scope of engagement, but still in the realm of immigration. So, and the way I deal with that issue, it's really just taking a look at what is the type of legal recourse or remedy. Some of our clients who are here seeking asylum have a particular type of expertise. So their employers are looking to see, hey, can we get them sponsored for something else? Do they qualify for some other type of business visa that we don't have the expertise? So also building really great referrals and resources for other legal areas as well, beyond immigration too. I say frequently comes up too. People are going through divorce proceedings or some type of child custody. So just really going back to the referring agency, having the conversations. And I think that all goes back to what we were talking about initially with just setting expectations and then rapport building with the client, because as acts change in the client's lives, things may happen that require additional legal
I think also it's incumbent on the agency, as we do, to the best you can assess whether someone is, whether the potential client is someone who's going to need a lot of other support, right? Is this someone that, is this a single mom who came with her two children who both have disabilities and are needing medical assistance and need housing assistance and all that stuff? Maybe that's not a case that you want to refer. To the extent that you have the capacity in-house, keep that case in-house versus referring out a case of someone who seems, again, the intake is, an hour, and then maybe you have a couple of follow-up conversations. So, you can't always anticipate the needs, but, from those brief conversations, you can assess a little bit about whether or not this is someone who is going to need less hand-holding, because these are human cases, right? They come with a lot of other issues, and are they issues that we like Remain has a social service project in-house, right? So we have the ability to pair cases with a social worker for those that we keep in-house, and so maybe that's a good use of our resources versus cases that could just be referred for just the legal case.
I think I'm going to give one more gift. Give this gift to your pro bono attorneys. I'm not an expert in that gift. right? An attorney can always say, I really would like to help you, but I'm not an expert in that. Here's some people that I think can help you, or I'll see what I can find and give you a list, right? But I'm not an expert. I'm an expert in this law, not, in this type of case, not in this thing. Is something that I found clients really respond to, right? Like, oh, right, of course you're not a universal, like, I don't know, doctor, lawyer, social worker, mental health provider, benefits enrollment person, and like driver's license production person, right? So that's something they can really understand. And if you give that to the attorneys, then they can just keep it and use it as they need.
Next topic, how can you coach and advise your pro bono attorneys and prepare them for potential conflicts of interest that may come up during their representation? I'm going to start with Emily on this one.
So again, I think it comes back to that expectations conversation up front, right? Which is why I always, even though we have the conversation with the potential client during the intake about potential conflicts, who's an adverse party, who's on their side, that is a conversation that should happen multiple times throughout the case, right? Because things change. You might refer out an SIJS case where it's mom who's petitioning for custody over the child, and then the child-parent relationship deteriorates, and now you've got a conflict between the child and the parent, right? And so what happens there? Obviously, that's not something that can necessarily be remedied. We often consider in SIJS cases where generally the adult is the one petitioning for the custody arrangement over the child. There are in Colorado ways to have the child petition the court for a guardian to be appointed. That avoids any conflict because ultimately it's the child who benefits from the immigration relief. And so that avoids a conflict situation. That attorney can continue with the child just with a new guardian if that relationship deteriorates. So it's that setting up the expectations and setting up that conversation and that constant review of who is allowed to be part of the case, who is not allowed to be part of the case, and what the relationship is. We also, when considering whether or not to refer cases where it's a whole family, for example, in removal proceedings, and the children are SIJS eligible, but the parent has an asylum claim that we wouldn't normally refer out, we're not going to refer out those kids' cases. We may try and help them find another organization that would be able to help them with that SIJS portion, but because we think that there's an inherent disparity between the sort of the power there, because mom isn't getting an attorney for her asylum case, and it's hard to understand why her kids can have an attorney and she can't. We find that it's just easier not to refer out the cases. So making that assessment up front and having a policy up front of what cases you avoid, what cases you avoid referring out for conflicts issues.
And I think, for our end, so we do have our cases go through a conflicts check. So once we partner with a referring agency, we receive the information, we do a conflicts check through our conflicts department, and then really the expectation setting in communication with the clients and also in the engagement letter. I mentioned that we sometimes, when cases oftentimes are referred, if it's an affirmative case, we will tailor the engagement letter to be specific to we are representing you in the affirmative asylum. So the expectation setting, so that if then the client marries and maybe there's an opportunity to file a green card, they know, okay, we're going to have to do another conflicts check because now there's another party involved, see if there are additional conflicts and expand the scope of engagement. We're not automatically going to now take on the adjustment case, right? So I think that really helps. And then also we have, oftentimes we're representing derivatives as well on U visa applications or VAWA applications. So the language that we communicate to the clients and in our engagement letters clarifies who the principal client is, waivers of conflicts of interest, steps that we have to take if there is a conflict of interest that arises. So we're having the communication several times as well. As Emily mentioned, I think that's what you have to do, especially given the nature of how long immigration cases may pend for, right? So a derivative may have a great relationship at the onset of the case with the principal U visa applicant, and then something happens in their relationship. Well, we have to reevaluate and see, based on the engagement, what we can do now for the two individuals. So really having those conversations frequently, and also checking in with the clients and just staying in contact with the clients, because, for example, with U visa cases, if it's pending 7 to 9 years, continuing to see what's going on in the client's life, because sometimes people, I think we've mentioned this throughout this webinar, that it's not necessarily intuitive what matters for the legal immigration case or what does not. So, hey, I had a falling out with my son, maybe isn't raised, and then time goes on, and you don't want to then have the U visas arrive to your office, and then you're trying to figure out, oh, is this person still a client or not? So trying to avoid things from the onset, and frequently communicating with clients.
Yeah, so I just put a bunch of links in the, I think in the chat, I think I did, that provide some guidance in a bunch of different scenarios. There's some where, obviously conflicts are going to come up between people, but you may also, I'm not sure what that means. So I'm going to let someone else figure out the links, and I'll repost them if you didn't get them. But I think there's conflicts of interest, between clients, but there may also be other reasons why a pro bono attorney might either want to withdraw or feel like they have to withdraw or otherwise be afraid of continuing with the case. So I just want to flag some of those. And, the conflicts of interest, obviously, between family members, it depends on the stage of the proceeding and what the actual conflict is and whether there is really a conflict or not with respect to the scope of what you're doing. And I think probably SIJ and family cases are the most rife with client conflict issues because you are representing more than one person for the purpose of a single case. But I think a lot of times attorneys get really afraid if either the client lies or the client has some kind of criminal issue come up. Those are sort of the two things that really seem to throw pro bono attorneys, and I think people who are pro bono coordinators probably have noticed that too. So, again, I think prevention is the best medicine, right? So the most you can prepare pro bono attorneys, for the possibility of different things coming up, and then what to do when they do come up in order to work through them, then you can possibly avoid a panic. But I think the important thing to stress is that, right, there are actual ethical guidelines about what one is to do in such a circumstance, right? It's not a moral judgment from the attorney about whether the client is good or bad, whether, the whatever other thing is influencing the attorney. So, for example, if clients are not truthful about something, right, in some cases, you might have to withdraw. But actually, in most cases, you don't, right? Because the issue is if the client lies on the stand. But if the client has been untruthful with the attorney in a way that the attorney can work with the client, figure out why, where did it come from, and are we able to rehabilitate that? Has it actually been presented to any authority yet or not? And if it's a breach of trust issue, is that really ethically an acceptable reason to withdraw? There you have to look at the harm you would cause the client. And so I think in the links, I might have linked to the model ethics rules, but each state has their own rules around withdrawal. And so that's an important sort of tool to use if an attorney wants to withdraw. I want to give one example because it was like the life-changing example for me. But I had clients for whom I had worked very, very hard on a very, very emotionally fraught case. And they had essentially, I had the public documents of the criminal charge and the ultimate conviction, but I did not have the full police report and other background documents. And essentially, actually happened. And that lie was relevant to what we were trying to do. And after a lot of like research about what I was supposed to do and thinking about like what was the ultimate goal of the representation and whether that lie, yes, it impacted the ultimate goal, but was it actually a problem? The outcome that I came to was to simply withdraw. There was one statement about that, that criminal charge in one document. And so what I did without other explanation was to simply withdraw that statement and otherwise proceed with the case. And that was the way that I found to thread the needle, where I wasn't making any kind of false representation. But, in the case of these clients, I really understood why they lied. They were really afraid. This was a really emotional situation. They had not had situations where they could trust authority figures in the past. I saw a lot of reasons, and personally, I was hurt, but that I had to separate that from my obligations as an attorney in this particular case. And so that's the kind of thing that's probably going to need handholding from a pro bono coordinator, but it is not the kind of thing where there should be a knee-jerk reaction to sort of like, nope, I'm wiping my hands clean of this, I'm out. Because ethically, that's actually not permitted in many cases. And then the second thing I want to flag are criminal convictions and criminal charges. I think many pro bono attorneys are uncomfortable with criminal convictions and criminal charges. And so there's, again, up front, a lot of framing that needs to happen, understanding of sort of the inherent racism in the criminal justice system and sort of looking at systemically how criminal charges and convictions actually happen. And then secondarily, like separating the moral judgment from looking at the case facts and analyzing legally what the issues are. So this is something that takes practice, right? Some people just like get it, and some people really come from a totally different perspective. So those types of issues, if a attorney thinks a case is no longer winnable or thinks like, oh, I have to just finish with this, I think it's worth maybe even having some kind of tool where you can say, like, in the event of criminal issues, like, call me, or do X, Y, and Z before making any kind of decision, so that the initial panic is not what leads to the actual action in the case. So yeah, I think
That's
go ahead.
Oh, no, I was just gonna say that's a great point. And what we communicate to our clients, and then through telling our attorneys to communicate to that client, hey, if you move, you have to let us know because it could affect your case. If you get arrested or you're stopped by immigration or any type of law enforcement, you have to let us know because it can affect your case, which then naturally leads to people reaching out, our pro bonos reaching out to me and saying, hey, XYZ has happened. Can we get on a call and talk about what this means for the case? So I think it helps alleviate the panic when it's just a statement that we are constantly communicating. It's like moving, client communications, very basic things that we must know.
So there's a couple of questions that have come in, and one of them is actually about the topic we're going to get to next, and I think that can kind of be a great ending point. But how do you recommend broaching the conversation when there are issues with the attorney performance? How do you address attorney performance issues, and I guess when the attorney is not paying the needed attention to the case or is handling the case in a manner you disagree with?
I can start with my preferences from our firm side. I like to hear about that. So if that's going on in any of our cases, of course, I want someone from the referring agency to reach out to me directly and say, hey, can we get on the call? Or here's what we're seeing. Maybe there's something that's going on that, one, they're not aware of regarding the attorney. But then two, I think the position that and I don't know if this is true for everyone, but sometimes I find that because I am a resource internally at the firm, people are reaching out to me. So maybe the communication is not as good as it can be going back to the agency. But it's like, yeah, we've done all these things. Oh, the mentor at the agency changed and I forgot that I was supposed to email this person instead of that person. And so sometimes it's a lack of communication. So improving our communication, but actually the work in the case is going well. And then yes, there might be instances where there are things that need to be improved, or there are things that need to be addressed. So I think it's a really good to reach out to the person that the referring agency is handing the case off to, and to then kind of have the conversations with the pro bono attorney. That being, if the pro bono attorney is not being responsive, if they've reached out directly and they're just not hearing back, and or there's a need to kind of like escalate the communication, so to speak. That's, I think, right.
Yeah, and we at Remain, when we refer a case, we refer it with a memo that has all the steps, right? It has all the steps. Now, that doesn't sort of describe how they need to research the country conditions or anything, in detail, but it does give the steps. And then we have kind of a check-in with the pro bonos where we, call or email after a certain period of time and say, hey, how's it going with this step? Or have you managed to have your initial conversation with the client? Or, with an SIJS case, has the guardianship petition been filed? Just kind of as a way of checking in. And then with certain types of cases where the law changes or the policies change a lot, we ask pro bonos to send us, for example, their drafted predicate orders for SIJS cases before they ask the judge to sign them, just so that not only can we check and make sure that they followed our template, but also that maybe something else came down from CIS and they started issuing all these RFEs on the factual allegations or whatever it is. We can say, whoa, actually, we need to start adding these things. You got this case before that became an issue. So it's just kind of constantly checking in, which is, it's difficult when you have a lot of cases that are referred, but having a systematic way of checking in is a way to just kind of confirm that things are happening on the case. And then if they aren't, having that difficult conversation of saying, this is not adequate representation, we're going to have to take this case back. We're going to have to re-refer this case. We appreciate your willingness to take the case, but we need this case to move faster, or we need this case to go in a different direction.
Yeah, and I think, Emily, there was a question that just came in asking, about what you do whenever a pro bono attorney has missed a deadline that you've specifically warned them about. So in that situation, is that a situation where you go back to the attorney and you say, all right, you missed this deadline, we're going to have to take the case back, or kind of how do you address that situation?
So we've had this exact experience with a pro bono who missed the 1-year filing deadline on an asylum case. And in that case, the pro bono was mortified and absolutely horrified and wanted to do whatever she could to fix the case. And in actual fact, we were able to work with that pro bono to stay on the case, in fact, because we approached the government attorneys and said, hey, this is what happened. She threw herself under the bus and said, this is all on me. This is my fault. They were trying to file the application, and the government agreed not to make an issue of the 1-year filing deadline. And so she was able to proceed with the case. And so that was a situation where we were able to rehabilitate the attorney-client relationship. And again, if the client had said, no, I don't trust this lawyer, they messed up my case, we would have taken that case back and would have, probably had to grieve the pro bono attorney, and which we never want to do, right? That's never something that we want to do. We want to find that common ground to try and rehabilitate the case, but sometimes we do have to do that.
Maybe if I could just add, on the point of what we started the conversation with, expectation setting. So, coming from a perspective of, okay, perhaps this pro bono attorney has never worked on an immigration case. So they're learning the language, but also learning deadlines, also learning things. So internally, I've built different tools to help people. And I know that a lot of agencies reach out regarding deadlines. So it's, I think as far as that communication between pro bono at the firm and pro bono at the referring agency, whoever is doing the handoff between the case, having really good communication between those two entities to make sure that everything stays on track, because there are a lot of things, like I-589 deadlines and work authorization renewals, and so things can get lost. So it's just, and with attorney transitions at the firms and at referring agencies, just making sure that we're kind of all communicating and keeping up with the deadline. So the check-ins really help with that. And with a lot of different agencies where we take on a lot of cases, I've set up sort of every 6 months, I will get on the phone with the pro bono coordinators at the referring agencies, and we will audit our list of all the cases. So that's in addition to checking in with the attorney who's handling the client case directly, but it's this extra step of, okay, are we on the same page about these cases? Do we need to do anything else beyond what we're seeing in our community? Work for us, but but a good way to ensure that everything is getting done, or as much as possible.
So I would encourage everyone, we have just a couple minutes left, so if you do have questions, please go ahead and put those in the Q&A. But I am going to go to Becky really quickly, because we had a question about how to approach withdrawal when a conflict arises between clients, and how to have the best conversation, how to have a conversation with a pro bono attorney about that.
Yeah, so I think what you want to do in that situation where there's a conflict, once you have identified that this is actually a conflict that requires withdrawal, right? Because the first step is, can you just sort of get around it, or do you actually have to withdraw, right? So if you actually have to withdraw, I think the things you need to think about are, what information can you actually share with both clients about the reason for the withdrawal? What information can you actually share, and what information should you not share with the agency that you're notifying about your withdrawal? And then how do you refer those clients to other representation so that they're not harmed by your withdrawal? I guess, and then lastly, this sort of goes with what can you tell them about the withdrawal, but is it possible to give them advice to avoid the same conflict in the future, right? And sometimes it is and sometimes it isn't. But the key things there are really, once you do that, I think generally you can't place a case that you are withdrawing from, right? Because then you're still involved in it. So you have to just give the referral list, or 3 referrals you think could possibly take that case, and then you have to get out of the case. That is the way to cleanly withdraw. But ahead of time, to each client, you have to decide what is it that you say to each client, and how do you explain that this is going to be happening. When we've had to do it, it's actually been okay, even though it feels really scary to us. But usually we say, there's an ethical rule. We can't represent you anymore. We're really sorry. We want the best for you, but this law says that we have to be done. And we suggest you both get separate attorneys in the future, right? Or we suggest that if it's apparent, if you're withdrawing because the case is no longer viable, that is sort of a separate reason. But assuming there's an actual conflict between the individuals, you can suggest how they could be successful in retaining their representation going forward. And that might be, you both need separate attorneys. That might be, well, if you tell an attorney that X has happened, they will have to withdraw, sort of prospectively. But that, may or may not be possible depending on the case. But I think that's how you frame it for the pro bono attorneys once you've identified that they do need to withdraw.
Last question, if we can cover it quickly. Do you use written agreements defining your role in the placement process? And are there confidentiality waivers or other processes to allow sharing of information?
Can I jump in and just make one more point on withdrawal that's related to this?
Sorry.
Hopefully, in your agreement that you have with the client, it explains why you would need to withdraw in event of conflict, and that should also be sort of the touchstone for those conversations. So hopefully, yes, there are agreements, and that agreement is useful in all situations, including withdrawal.
Our engagement letter specifies like all of the, potential reasons why we may need to withdraw. And of course, we have that, provided to the client in their native language as well. So just making sure that everyone is understanding what they're reviewing. And we do ask for waivers if we're going to be written waivers if we're going to be asking for information from other people or communicating with others.
Yeah, and we provide sample retainer agreements for our pro bono attorneys that aren't necessarily with firms who have sample engagement letters. And again, they're in both English and Spanish. That's the majority of the language that we refer out. And are very clear about the situations of where withdrawal will become required.
Well, that's all the time we have, but before we leave, I ask all attendees who want CLE credit to please stay connected for instructions to get your CLE certificate. I really want to thank Narina, Becky, and Emily for sharing your expertise with us. I think this is a topic we could probably talk all day about. There's so much I think that we could discuss. Thank you again, everyone, for joining us, and thanks to our panelists.
Thank you very much to our speakers. And on behalf of the American Bar Association and the ABA Commission on Immigration, thank you for participating in this program. To learn more about our sponsors, visit the ABA website at americanbar.org. Thank you, and please click on the evaluation link. We value your feedback. For those of you who want CLE credit, please click on the evaluation link that's currently appearing on your screen. This will open the program evaluation, and after you submit the evaluation, the attendance confirmation form and request for CLE credit will appear. Please complete the information requested on the form and submit it. If your information is verified and your attendance meets all the requirements for CLE, your certificates will be emailed to you. Thank you very much for calling today. That concludes today's session.